This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. Did you know live Senate video is now available at youtube.com/@Senate of Virginia? Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Welcome to this committee meeting. Please ensure that telephones and other noise-making devices are silenced and powered off. The consumption of food and beverages in Senate rooms is prohibited. If you wish to address this committee, please be prepared to approach the lectern when public comment is requested. Identify yourself for the record and observe the stated time limits.
Thank you. Please open the roll.
Mr. Chair, you have a quorum.
All right, we have a fairly light docket, depending on our colleagues' testimony and comments. But we have identical resolutions that we're going to report out. We're not going to take any testimony on because we heard these before. They are exactly identical to the constitutional amendments we already passed out. So with that, can I get a motion on HJ1?
Move we report.
Second.
There's a motion, there's a second. Please open the roll. Yes?
There's nobody here to answer questions.
Well, as chair, what is your question?
So something came up about one of them today.
Yeah, well, that's Senator Markar. You can that's fine to be noted for the record, but we're not taking any testimony or comments on it. They are exactly identical to the ones we already passed out. There's been it's exactly identical.
You're identical.
There's a motion. There's a second. Please open the vote. All right, HJ1 reports. HJ2.
Move to report.
There's a motion. There's a second to report HJ2. Please open the vote. Thank you. Bill reports. HJ9. Please.
Report.
There's a motion and there's a second. Please open the vote. All right. And now, all right, thank you. Now we will take bills that have been exactly identical to the ones we had last year. We have Senator Borsko's waiting, so I know she has to get to another committee. Senator Borsko, brevity is your friend.
Thank you, Mr. Chair. SB 1002 is regarding the restriction of personal use of campaign funds. It is nearly identical to last year's. The one change is that there were some concerns around people misusing this for political advantage. This simply states that if someone lodges a complaint, there's a 10-day waiting period before anyone, while they research it, before it can be made public, in order to protect the individual in the event that it's not a valid argument. But it restricts the use of campaign funds for all candidates. It passed through the Senate.
Yeah. Yeah. Thank you. Is there anyone to speak in support of the bill? Please come to the podium. You have 3 minutes.
Those online who wish to speak in support of the bill, please raise your hand.
Hello, thank you, Chair Rouse and members of the committee for considering this really important bill. And thank you to Senator Boysko for her leadership over the years on this issue. My name is Wes Gobar. I'm speaking on behalf of Clean Virginia and also as a board member for the Virginia Conservation Network. I'm proud to share that our coalition of over 160 environmental organizations officially supports this bill as well. The Campaign Integrity Act, or the ban on the personal use of campaign funds, will restore public trust at a time when many of us really need reminding that democracy can work for the people. I'm proud to be a Virginian. We rank at the top of the nation when it comes to education and places to do business, but at the very bottom when it actually comes to issues around integrity, good governance, and campaign finance. In fact, we rank 46 out of 50 on a national ranking, the SWAMB Index, for anti-corruption members across states. There's no reason why anyone should be able to use their campaign funds to pay for a country club membership or Rolex. And there's no reason why Virginia should be one of 2 states with no restrictions on the personal use of campaign contributions. So it's time to fix this state of affairs and have Virginia now rank number 1 on good governance. Thank you.
Mr. Chairman,
Pause the clock.
just had a question.
Senator
for the
Abbott.
witness. I mean, I support the bill, but are you alleging that people are using campaign funds now for country club use?
These are all things that are allowed.
Hypothetically.
Yes, but
Okay.
there are past news stories. You can look at members who are no longer, there's some for members in 2021 who are no longer in office.
Thanks.
Saying anyone here is using.
Thank you.
Thank you. Please continue the clock.
Good afternoon, Mr. Chair and members of the committee. I'm Mary Crutchfield, speaking for the League of Women Voters of Virginia. The League of Women Voters of Virginia supports legislation restricting personal use of campaign funds. Virginia currently has no legal restrictions on how campaign funds may be used. The League believes that funds raised for a campaign should be used only for expenses directly related to running for office. We support the expanded provisions for what constitutes personal use and the provision disallowing converting any funds to personal use, not just surpluses at the end of a campaign or term in office.
Benjamin Knotts, America's Prosperity. We think that donor intent is something that people need to consider. And when somebody gives to a campaign, they think that that's the intent, that they want it to be spent on that campaign. So that's why we support the bill. Thank you.
Thank you. We have 2 speakers in support online. Please ensure your camera is on in 1 minute.
Bill Millhauser, you may begin. You are muted.
My name is Bill Millhauser. I live in Falls Church, Virginia. Mr. Chairman and members of the committee, thank you for allowing me the opportunity to speak to you today. It's absolutely essential this bill be passed to put into law an explicit statement that personal use of campaign funds is no longer allowed in Virginia. This bill has come before the legislature for almost 11 years now. It's time to pass it. I think the serious concerns raised last year about frivolous complaints and malicious complaints has been resolved, and I urge you to pass this bill. Thank you so much for your time.
Thank you, sir.
Nancy Morgan, you may begin.
Thank you, Mr. Chair. Nancy Morgan, I am coordinator of Big Money Out, a all-volunteer, nonpartisan group working on campaign finance reform. And as my colleague mentioned, 2014, this was introduced and it's been introduced every year. And as it was said, it's not a gotcha bill. Rather, revisions to this bill come from the 2021 Campaign Finance Group and a robust and confidential complaint process, 2 pages of the bill to protect legislators from being attacked. It moves Virginia forward in terms of good government, supported by 73% of voters. Please pass this bill so we don't have to come back next year. And thank you, many thanks to Senator Boysko for championing the bill. Thank you.
All right. Thank you. Is there anyone speaking opposition on the bill that's in the room?
Those online that wish to speak in opposition, please raise your hand.
Is there any? I see anyone? We'll be on that. Is there any comments from the committee? All right, heard a motion, didn't hear a second.
Second.
There's a motion and a second to report. Please open roll. Oh, and it's, please amend your motion to report and refer to finance.
Okay, second.
All right, it's been second. Please open the roll. All right, that bill reports to finance.
Thank you, Mr. Chair.
Knows one.
All right, thank you. All right, since we have Senator Servell here, we'll take Senator Servell. Senator Servell, what bill would you like, sir?
Say what?
Which one do you want to start with?
775.
We already heard, and I have a substitute on that. I don't know if we want to start where we left off on that, or that was 940. Yeah.
Yeah, start with that one.
Yeah, there's a sub.
So motion and a second, to move to substitute. All those in favor say aye. All those opposed, substitute has been moved. It's properly before us. Can you explain the substitute, sir?
Yeah. Brooks, is it posted online? Okay. So we basically just tried to redo the deadline so that they made more sense. Which sub is it? I'm not seeing the right sub. I'm seeing two subs online. Oh, is the one on top? Okay, got it. Okay, so basically we restructured it basically to say that Section A sort of sets the deadlines. Remember, this is the deadline to challenge a candidate's qualifications other than their residency. So if they've screwed up their petition paperwork or had an inaccurate notarization, their certificate of candidate qualification or something. So we basically restructured it to say and we did this in part because the Supreme Court said that they thought they needed 45 days to litigate it if it was going to be expedited. So I tried to set the deadlines as far back from the day balloting starts as possible. So there's 45 days backwards, so there's time to litigate it before absentee ballots go out and voting starts. The idea is to keep this out of voting so voting doesn't get disrupted. So if you look on subsection A, line 18, it says the challenge has to be filed at least 90 days before the start of a general election, 65 days before the date of a primary, 70 days before a special held on the same day as a general, or any special held at a time other than a general, at least 55 days before the date of the special, or within 10 days of the writ of election if it's a compressed period of time. So those are the filing windows that you have. So that would hopefully keep the litigation and the uncertainty out of the voting period. Then it says that you have to file in the largest county if your district overlaps jurisdictions, and which would be the legislature and some constitutional offices. And then it says at the bottom that these deadlines don't apply if you want to challenge where somebody lives, because that's constitutional and that's not something we can.
And this is the substitute you're speaking to?
Yeah.
All right, thank you. We have a question by Senator Servant.
Mr. Chairman, Senator Serva, I like the bill. I'm just thinking about the 90 days before the general election day, or before voting starts?
Before the general election, the date general election, so it's election day.
Okay, so then it would be 45 days before early voting starts?
Yeah.
Got it, okay, thank you.
Thank you. Is there anyone here to speak in support of the bill? No, anyone online?
I doubt it.
Line that wishes to speak in support of the bill, please raise your hand.
Okay, anyone in opposition of the bill in the room?
Those online that wish to speak in opposition, please raise your hand.
Any comments by the committee?
Move to report as substituted.
All right, there's a motion and a second. It does not have to go to finance, or does it? All right, well, the vote is open. Please vote according to your preference. Thank you.
0.
That bill reports. All right, Senator Servo, you have SB 775.
Yeah, and there's a sub on this one. There's some cleanup some people requested.
Second.
There's a motion to move to substitute. It's been properly second. All those in favor say aye. All those opposed? That substitute's before us now. Can you explain the substitute and?
Sure. This bill has to do with AI in basically disclosure of AI in election campaigns. So what the bill does not do is ban AI. It simply says that if somebody wants to use AI in an election-related communication, they got to put a big label on it, so you know you're looking at something that's not real. So if you look at lines 14 through 20, that defines what AI is, and it's basically something that's created using something that doesn't depict the candidate. It's realistic, so that you can't sort of tell whether it's real or not, and it's dependent on technical and artificial instead of like using your hand or paint or something like that, right? Then lines 21 through 33 defines what's journalism and what's news, so that the journalists and the news organizations don't get caught up in this by reporting about it. And then 37 through 42 is kind of the meat of the bill. That provision describes sort of what you can't do. So basically says you can't knowingly disseminate AI media to influence a campaign without this conspicuous statement on it. So you have to say does not represent a true recording of the candidate and has to take up at least 33% of the viewing area for 5 seconds.
Thank you.
That's what that says. And then the last part, lines 40 and 59, creates a civil cause of action so that you can enjoin it, so you can get it taken down. And it says the courts have to give priority on the docket, so it doesn't take like a year to litigate it. You want to get that down as soon as possible. And then there's also language in there about damages. So you can get attorney's fees and stuff if somebody puts it up illegally, and it excludes the broadcasters from it. And then on line 60 through 70, that has some of the exclusions, which were requested by broadcasters. And the exclusions are anything that's satire or comedy, C-O-M-E-D-Y, not comma T, comma D, that's done by a human, not AI comedy, but comedy done by a human. And it excludes TV, radio stations, broadcasts, and that kind of stuff. I will tell you right now, I'm not sure if they're here, but I don't see the broadcasters here.
Thank you.
Back here, okay.
Senator,
Broadcasters basically wanted me to include parody or comedy that uses AI.
mm-hmm.
And I didn't like excluding that from the disclaimer, because I think what constitutes comedy or parody can often be in the eye of the beholder.
Senator Chervell, we do have a question from Senator Sturdivant.
I can wait till this.
All right. Do you have anyone to speak in support of your bill?
I don't know. I didn't bring anybody, but.
All right. 2 minutes, please. Please add 2 minutes on the clock.
Legally, this AI comedy parody thing is really complicated, and they wanted to include it. I didn't because.
Senator, you will have last words.
Okay.
Yeah.
All right.
2 minutes on the clock, please.
Those online that wish to speak to the bill, please raise your hand.
Mary Crutchfield with the League of Women Voters of Virginia. The League of Women Voters supports SB 775. Political campaigns and communications have many ways of disguising their sponsorship, adversely affecting voters' ability to make informed decisions. Requiring that artificial audio or artificial visual media be clearly marked as doing so, with violators subject to criminal and civil penalties, is essential to a well-informed electorate. We also are working with Senator Saravel's staff to add language, expanding the bill to prevent misrepresentations, including appearance of election officials and government authorities, as well as candidates, for a longer time frame.
Thank you.
Thank you, Senator Saravel.
Thank you.
Thank you to the chair and the committee for considering this legislation. My name is Wes Gobar, and I just wish to speak on behalf of Clean Virginia and express our support for Senator Saravel's bill. Thank you.
2 people online.
Nancy
Please.
Morgan, you may begin.
Please ensure that your camera is on. You have 30 seconds for your remarks.
Thanks, Mr. Chair. Nancy Morgan, coordinator of Big Money Out. We support this bill because it protects candidates, legislators from obscure ads which misrepresent their positions using synthetic media. We would obviously favor a more broader disclosure bill on electioneering communication, but this is a step in the right direction. Thanks, Senator Saravel.
Thank you.
Jackie, please turn on your camera and unmute your microphone and begin. Jackie, you may begin.
Okay. Is there anyone in the room to speak in opposition of the bill? Is there anyone online in
Those
opposition?
online, please raise your hand.
All right, we have Senator Sturtevant. You have the floor, sir.
Yeah, thank you, Mr. Chairman. Question for Senator Servo. Yeah, I mean, isn't there a major First Amendment concern here with this legislation? I think, number one, we're defining what constitutes journalism. It's defining what constitutes a news organization, defines what constitutes a news person. So there's the freedom of the press issue, and then there's the substance of the bill, which is making it a Class 1 misdemeanor where you can be put in jail for up to a year for sharing a meme on the internet without having the disclosure, if I'm understanding the substitute correctly. So I guess I wonder if you can comment on that from kind of a constitutional perspective, and, especially in the context of a political campaign allowing people to express themselves in diverse ways, which includes sharing videos and memes on the internet. I mean, this would pretty severely constrict that or restrict that, wouldn't it?
No, it actually doesn't restrict anything. It just requires a label.
Gentlemen, please go through the chair.
Yeah.
Thank you.
Yeah, no, it doesn't restrict anything. It just requires a label. We define journalism in other parts of the code for other reasons. I'm just poking around right now, but 19.2, we define journalism for purposes of witnesses and evidence in court. The word, I want to say, I've been down this road before and I can't remember why, but for some other types of exclusion, I can't remember if it's under FOIA or something else, or I know what it was. It was, there's been some stuff we've done about this, making people take down mugshots and expunge criminal records, and whether or not exactly what kind of journalism was excluded from that. But in any event, this has been done in other states. It's withstood court challenge in other states, and that's how I got the idea. It doesn't say what you can or can't say. It just says if you're going to say it, you got to put a label on it. And you're welcome to ask counsel about it. You have a lawyer here who helped me write it. Actually, 2 lawyers in DLS helped me write it. But it doesn't prohibit you. It just says you got to put a label on it so people know it's not the real thing.
Mr. Sturtevant, you have a follow-up?
Yes, thank you, Mr. Chair. So, if you're a grandmother sharing a meme on Facebook and that doesn't have the disclaimer on it, that the grandmother sharing a meme on Facebook is potentially liable for a Class 1 misdemeanor. That's sort of first follow-up question. And then second is, I don't know if the definition of news organization would include like some of the folks who cover the General Assembly who have, they're independent journalists and do it with a Substack and their Twitter account. And maybe I'm missing that in the definition here, but it just seems like we're kind of getting into some muddy First Amendment waters. We're trying to define this.
Yeah, and we've had to deal with that before. I remember, I think it has to do with the same thing I was talking about before, but sometimes it can be kind of ambiguous as to who's a journalist and who's really a journalist and who isn't. And that's why we have to define it, just because, and that's why it talks about, having newspapers issued at regular intervals, having general circulation, being recognized by a press association or wire service, that kind of thing. As to your first piece, it has to do with the person who knowingly disseminates something without a disclaimer that when they're intended to influence a campaign. And so I would submit that the first person that shares it, the person that's back on whatever that YouTube is or Instagram or wherever the whole thing came from, that's the person who has the real liability at the end of the day for putting this up. And I would think that having these consequences on here would allow for some swift remedies.
All right, thank you. Senator Cyphers is in the queue, and then Senator Sturtevant, come back to you.
Mr. Chair, my question is similar because, if a meme or something like that's created, it can be shared from the source, but it can also be saved and redistributed. And my question is related to if someone unknowingly redistributed something that was created with this technology, who's the arbitrator of knowingly?
Well, if somebody, it depends. I mean, if it's a civil action, it'd be a judge. If they try to initiate a criminal case, they'd have to prove to a magistrate that, or a police officer, that the person knowingly disseminated it. If they can't show it's knowingly, then no charge would issue. But that's why I put knowingly in there. You have to show that the person intentionally knew what they were sharing wasn't real and was missing that disclaimer. And by the way, the other state that passed it's Colorado. Colorado passed a law similar to this. Their attorney general has issued warnings to people not to share stuff, so they. No.
Senator Sturdivant.
Yeah, thank you, Mr. Chairman. And this will be my last follow-up because I know we have a lengthy docket. But, Section B says a person who knowingly disseminates artificial audio or artificial visual media intended to influence a political campaign shall include a conspicuous statement at the beginning of such media. And if they don't include that conspicuous statement, they're guilty of a Class 2 misdemeanor. So I think that does cover the grandmother who shares the, AI generated video. There was many going around this past election cycle of, both presidential candidates. I think just sharing it, you don't even have to be the creator, and exposing people to some pretty significant criminal liability in what is normally like a pretty well-protected First Amendment area. But that's, I won't follow up again, but thank you, Mr. Chairman, Senator Servo.
Thank you, Mr. Chair.
Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, Senator Servo, here's my question. So here's where I'm getting a little tripped up. So if I was the person who made the Donald Trump, Elon Musk dancing video that went viral on Twitter, I don't know when that was, in September or October. I mean, that's an artificially created media that I think was intended to influence the election in the sense that it's trying to make Donald Trump and Elon Musk seem cool or go viral. I agree they're not, but it makes them feel like it tries to, right. And that's influencing the election, but I don't think it's getting at the core thing that you're trying to talk about, right? Which is you're trying to talk about if I make a video of Donald Trump making a comment that he didn't make that would be harmful, right? So does the bill distinguish between those two things? Do you see what I'm getting at?
Now, what it says is that it has to do with if you're trying to influence the race, and I believe that's the standard that, if I'm not mistaken, the Colorado statute used was attempting to influence the race. I don't know how to get it any more narrow than that, other than it trying to influence the outcome.
Yeah, I guess follow.
By the way, that's where all this parody and non-parody stuff comes in. Parody versus comedy, and exactly what it is. Right. I mean, I was talking to somebody earlier, and it's often legally, to me, it's almost like the difference between porn and comedy. I mean, porn.
Sure, you know when I see it. Yeah.
All right. Well, gentlemen, just a second. Do you have a follow-up question, or do you have comments? You can make comments when someone makes a motion, but I want to get to the questions for now. Senator Eben, you have the floor.
Thank you, Mr. Chairman. Senator Servo, I like what the bill tries to do, and we have several bills that were referred to JCOTS for study about use of AI and watermarks and disclosure and so forth. But I was concerned about line 37. If you, or not line 37, line 43, any person who violates the provisions of this section is guilty of a Class 2 misdemeanor. However, if such person knows or reasonably should have known that such artificial audio or artificial visual media is being disseminated, is deceptive or misleading, and it takes place 90 days before an election, etc., it's a Class 1 misdemeanor. So is the person guilty of a Class 2 misdemeanor if there's some grandmother sharing on Facebook who doesn't know that they're sharing false and damaging video, fake content?
When?
Is this only for people who are knowingly sharing this, your bill?
Okay, well, no, there's two knowinglys. Subsection B, you have to knowingly disseminate something you know is AI.
Right.
Okay? Then if you violate that, it's Class 2. If you want to make it a civil infraction, I don't care. The civil relief is really the most important thing to me, for whatever it's worth. The criminal relief is within the 90-day stuff, and it's if you knowingly put out something you know is within 90 days of an election, it's made without consent, and it's made with the intent to injure a candidate or influence the result of an election. Those are the three things you have to show they knowingly did for the criminal liability to kick in addition to knowing that it was AI.
So, Mr.
It's a pretty
Chair-
high standard.
So just to follow up, it's your representation that no one be charged under this unless they knew that they were sharing fake video or whatever you want to call it, or synthetic media or otherwise. There's no penalty for anyone who doesn't know that they're, okay, thank you.
Thank you. Senator Van Valkenburg, and then I want to move this bill forward. I want to call for the motion.
Thank you, Mr. Chair. Mr. Chair, Senator Serval, maybe this is for you, maybe it's for Brooks, maybe it's just for any lawyer in the House. I mean, does it make sense to narrow it to say something like a person who knowingly disseminates artificial audio or artificial visual media that's slanderous or libelous and intended to influence a political campaign, so that you're trying to just get at the things that's like harmful to a person as opposed to the dancing video that's, I think, pretty harmless and I wouldn't want to throw someone in jail for?
You're starting to wade into the territory that Senator Eben waded into with his synthetic media bill that we sent to Boyd Graves 2 years in a row, which he was attempting to go after slander and defamation via synthetic media, which is similar. But you got to remember that under New York Times v. Sullivan, the bar for slander and defamation in the political context is like Mount Everest. And so that won't really provide a lot of help.
Okay.
But I can tell you this was based on Colorado. That's what Charles Qualiato based it on when he wrote it. Brooks took it over, rewrote it. I'm satisfied it's constitutional. If you want to, again, take it down from class 2 misdemeanor to civil infraction, if you're worried about grandma.
Well, the bill is before us. Is there a motion?
Yeah, move to report a substitute. Okay. So, Mr. Chairman?
Senator Eben.
Move to report the substitute, the adopted substitute.
Second.
And there's the motion to report with the substitute and the second does not have to go to finance.
Oh, does it?
I said it does not have to go to finance.
Yeah.
Please open the vote.
As 8, no 7.
Say 7.
Great. Thank you.
Thank you, Mr. Chairman. Thank you to members of the committee here. First, before I offer SB 1050, I'll note that we have an amendment to be offered on line 15 after the word any, strike committee organized under the provisions of this chapter and insert candidate campaign committee, political action committee, or political party candidate committee. And I'll be happy to explain that once it's adopted. We're moving the amendment.
Is that amendment?
Yeah, it's
online?
yeah.
It
DLS
is?
has it.
All right. And could you explain the amendment one more time?
Sure. So line 15 introduced after to any strike committee organized under the provisions of this chapter and insert candidate campaign committee, political action committee, or political party committee. And the entire point of that was to address a potential constitutional issue that came up about referendum campaigns.
All right. Just a moment. We have the amendment before us. Is there a second?
Second.
All right. It's been properly second. All in favor, say aye. Aye. All opposed? All right. The amendment's before us. We'll explain your bill.
All right, thank you, Mr. Chairman, to the members of the committee. So the amended version of this bill is basically, at this point, it prohibits for-profit corporations, all corporations, from donating to political campaigns. Last year, you'll remember, I had my bill up that was just applied to public service corporations, and we had even narrowed it down more than that. It got out of this committee, it was re-referred over to finance, and it did not get a hearing in finance. So the bill died. So I've introduced legislation like that on 2 occasions. So this time I'm doing what I actually want to do because I figured, you know what? I need a different bill if the last one didn't make it out. So what are we trying to accomplish with this? This isn't about where we've been, it's about where we need to go. and where I think we need to go is to deal with a few things that we heard at the last meeting, which was, or last year, which is when we heard one representative of a corporation who said that they want equal access to be able to, quote, influence as much as everyone else, and they wanted to be able to be treated as everyone else. This does that. This does not single out any industry, any type of industry. This is all corporations altogether. And the bottom line on that is because they are for-profit corporations, they should not be able to donate to campaigns when they are going to attempt to profit from the bills that we put in.
All right, thank you, Senator Rome. You have anyone here to speak in support of the bill?
In support, please raise your hand.
2 minutes, please.
Mr. Chair and members of the committee, Mary Crutchfield with League of Women Voters of Virginia. The League of Women Voters of Virginia supports legislation that limits campaign contributions. Corporations, particularly public service corporations, and their political action committees should not be allowed to make contributions to any candidate's campaign committee or political action committee. The issue is the conflict of interest inherent in a corporation's donating to legislators who have control over the corporation's activities, and goes hand in hand with the public perception of corruption and pay for play.
Hello. Thank you to the chair, members of the committee for hearing this bill, and Senator Rome for her leadership on this issue. My name is Wes Gobar. I'm the Good Governance Director at Clean Virginia, and I'm also, as a board member of the Virginia Conservation Network, proud to share that our coalition of 160 plus environmental organizations also supports this bill. This legislation is a clear chance to restore faith in our democracy at a time when that public trust is failing. Virginia is one out of 5 states with no restrictions at all, or limits on corporate spending, and our elections keep getting more and more expensive. In 2023, Virginia had the most expensive elections in the country. It's over $190 million raised. Clean Virginia has consistently pointed out that the relationship between increased spending from regulated utility monopolies and Virginians facing some of the highest energy bills in the country. And the same thing is true when it comes to cost of living issues like housing, healthcare, price of drugs. And that's why it's time to take the profit out of politics and support this bill. Thank you.
Sir, please just state your name and whether you support or oppose the bill.
Jimmy Hart, Richmond resident, support the bill.
Thank you, sir. One person online, you have 30 seconds.
Morgan, you may begin.
Mr. Chair, this is Nancy Morgan from Big Money Out Again. Yes, we support the bill. 22 other states ban contributions from corporations, as does the federal system, since Teddy Roosevelt passed the Tillman Act in 1907. We'd prefer a more broad-based bill which supports limitations on everybody, because we've noticed personal checks of $100,000 or more to PACs and other entities. But this is a good step in the right direction. We're currently the wild, wild west of campaign finance. Thanks.
Thank you. Those in opposition?
Those
You
online
have,
in opposition?
2 minutes.
Please raise your hand.
Mr. Chairman, members of the committee, my name is Dylan Bishop. I'm here on behalf of the Virginia Oil and Gas Association. With all due respect to the patron, who I think highly of, I think this bill is rife with issues, not least of which being the Citizens United case that was upheld multiple times in the last 5 years. And I would also state to the folks that had spoken before me, if Clean Virginia is such a big issue with political giving, it just causes inquiry why they gave so much the last year themselves. So it's part of the American process, First Amendment right, and the ability to give political contributions is incumbent to that right. So appreciate it.
Mr. Chairman?
Thank you, sir.
Could we stop the clock so I could ask a question, Mr. Bishop?
Sir.
I just wanted to ask, you said that, mentioned Citizens United. I thought that the Supreme Court held in that ruling, which I don't like, that you could speak to influence an election or spend to influence an election in an unlimited manner, not give to a particular campaign in an unlimited manner. Is that not right?
Mr. Chair and Senator Eben, what Citizens United held was that you could not put undue restrictions on giving so long that it was not given in coordination with a particular campaign.
So
Well, we're not gonna litigate Citizens United here.
No, but I think he just misstated it, and I just wanted to be clear that you can spend it.
You have the floor, Senator Evans.
Thank you, Mr. Chair. I think you can spend as much as you want to talk about a candidate, but I don't think that even federally, an individual is limited to like $2,300 or $2,500 to a federal candidate. So I just didn't think that was accurate.
Thank you, Mr. Chair.
Thank you.
Chairman Scott McGarry of Washington Gas. I think it's worth noting in the case of the client I represent, donations are made to candidates strictly by a volunteer political action committee that is funded strictly voluntarily. No company funds are used, and appreciate your consideration and have the greatest respect as always for the patron.
Thank you.
Mr. McGarry? Yes. But this bill doesn't restrict contributions by PACs, so your employee PAC wouldn't be restricted, right? That was the amendment? Maybe I misunderstood.
Sure. Read back to the amendment. That was after, on line 15, after we struck committee organized under the provisions of chapter, inserted candidate committee, political action committee, or political party committee.
Maybe Senator Rome could explain it to me, because I'm not.
Like, if you want, Mr. Chair, if the senator wants to basically amend the bill so that it matches the thing that we did last year in terms of excluding PACs, that sort of thing, then I would get it. But I think this bill already covers what it is that you want, because it says no corporation that is organized under the laws of the United States or any state shall make any contribution or committee organized under provisions of this chapter. That's not about PACs. I can also defer to.
Yes, we hope we have legal counsel can perhaps clear up any confusion.
Mr. Chairman, Senator, so what the bill does is it prevents a corporation from giving to a PAC. But if the corporation, if there was a PAC that existed for the corporation's employees to give to independent of the corporation, then that PAC could still give money.
And Mr. Chair, to further clarify the other point, Citizens United applied to independent expenditures. That is not what is before you today. And we checked with that with DLS prior to filing the bill.
Thank you, Senator Rowe. We have other members of the committee who have questions. Senator Sturtevant.
Thank you, Mr. Chairman. Just a question for the patron on the amendment where it adds political party committee. No corporation can give to a political party committee.
Yep.
I think it sounds like that would include my local Chesterfield Republican committee. And so if they have their annual Lincoln Reagan dinner, a local business would be prohibited from sponsoring something at that dinner.
Mr. Chair, I would tell the senator I would view that as a feature, not a bug. But to be honest with you, the reason I wanted that in general is because, look, even in our caucuses, even with our state parties, even at our local parties, we don't want to use them as a funnel for, okay, we took out direct contributing to us, so then they're just going to give it to them, who then gives it to us. Like this easy, right? And I already know this bill is not going to end, corporations finding a way to give money somewhere else, but let's make it a little bit more difficult for them to have direct influence to the legislators.
Follow up, Mr.
Senator Sturtevant.
And I understand that, and I think the focus of your bill is on large, well-moneyed business interests and corporations. But the sort of scenario I'm talking about is lots of very, very small entities are corporations. A local pizza parlor that opens up to allow the local Republican committee in Powhatan to come meet at is a corporation. And if they provide them with, free food and drink, is that potentially running afoul of the law?
Senator Rowe?
Mr. Chair, I would tell the senator in that case that if an employee, including the owner of that pizza parlor, wanted to use personal funds to do that, they can do that. that's fine. If they want to, go into their personal pockets to do that with their own personal income, feel free. The point of this is to get corporate money to whatever extent possible and reasonable and lawful away from us.
Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, Senator Rome, perhaps a leading question. Does Joe's Deli that's incorporated funnel hundreds of millions of dollars to PACs and candidates over the course of an election cycle?
So, Mr. Chairman, I would tell the senator that Joe's Deli in that case very well could, or they couldn't. And if Mr. Joe himself or Miss Joe, I mean, it's spelled J-O, who's to say? Whatever the situation here is, that individual can go and still donate as much as they want, because we have routinely had legislation come up, including from the senator from Charlottesville, to try to put caps on giving to us. I have supported that. We haven't got anything out. I would love for us to have a cap that was reasonable and in continuity with this, but we have watched that legislation fail, and so I'm trying a moonshot here because I think it's important.
Now is the time the chair will entertain any motions.
Move to report.
Second.
All right, there's a motion to report. It's been properly second. With
as
the
amended.
amendment as amended. Please open the vote.
Ayes 8, noes 7.
All right. Bill reports 8-7. Senator Graves.
Thank you, Mr. Chair. I would like to move to strike Senate Bill 994.
There's a motion to strike. That is I think we have to vote on that on the board. Strike at the request of the patron. Please open the vote. All right, and now we have, thank you. That bill has been struck from the record. Now we have 998 in front of us.
Yes, and there is an amendment in the nature of a substitute.
So moved. Is there a second? There's an amendment, nature of a substitute. It's been properly motioned. All in favor, say aye. All opposed. Can you explain that amendment is,
Sure,
nature of
thank you.
substitute has been approved? Can you please explain the substitute?
Sure, thank you. As I was here last week, the goal of this bill and what is in the substitute is to protect voters who are driving up curbside from being accosted by the overly zealous campaign volunteers when they are ready to vote. And so in researching some of the information that was provided by Senator DeStep, I want to thank him for his information. That information, that particular section of the code includes that a car is a voting place, but it does not have the provisions for the 40-foot line. So in the substitute, as you will see in various places, including line 39, line 62, line 70, and lines 134, 135, and lines 144 and 145. We have that, the sentence starting, if you will, on line 38, and the establishment of a prohibited area within 40 feet of any entrance of the polling place and within 10 feet of any area designated for voting outside the polling place pursuant to section 24.2-649. So this just gives a 10-foot buffer from an area designated outside of the polling place from campaigning activity that would protect the people in the car who are voting once the registrar person has gotten their ID, and then they can go on about their business, make their vote, and move on.
Thank you, Senator. Is there anyone speaking in support of the bill?
In support, please raise your hand.
Sir, you have a minute.
Mr. Chairman, members of the committee, David Bailey with the Voter Registrars Association of Virginia, and we do support this bill. One of our leaders in the association said what we need is kind of a bubble around that area, and I think this 10-foot area hopefully will accomplish that and will give some more peace to the voters. So thank you.
All right, thank you, sir. Is there anyone in support? Please ensure your camera is on. You have 30 seconds.
Anne Gregorian, you may begin.
Yes, I would speak in support of this, but I would encourage, as somebody that's been an election official and somebody that's been a poll worker outside the polls, to encourage that this bill be somehow modified, that while voting, there'll be some indication that the car is voting, because prior to that, a person that's handicapped obviously can't get out if they want to get campaign material. And so it allows the campaign worker to know when the area is restricted because the person is in active voting, and when the person might not be restricted because
Thank you.
they're not voting.
Is there anyone speaking in opposition of the bill? Oh, was one more speak support? I'm sorry.
Stephanie Isles, please turn on your camera and unmute your microphone and begin.
Hi, Stephanie Isles. I'm the Director of Elections and General Registrar with the City of Norfolk. We'd like to thank Senator Williams-Graves for introducing this legislation to protect those citizens who are voting in their vehicle and unable to come into the polling place. This would create a buffer and allow them the same protections as those who come inside to cast their ballot. Thank you.
Thank you. Is there anyone in the room who is in opposition of the bill? Please come forward. Is there anyone online?
Those online, raise your hand.
Okay, is there any comments by members of the committee? All right, not seeing any, hearing any, entertain a motion. Should motion to report with the substitute, please open the vote.
Ayes 7, noes 8.
All right, that bill fails to report 7-8.
Thank you, Mr. Chair.
Thank you, Senator. All right, next, before we take Senator Stanley, SB 1185 needs to go to rules. Is there a motion?
So moved.
Second.
Second. 1185 to go to rules. Been properly motioned and second. Please open the vote. Yep, straight refer.
Ayes 15, no 0.
Thank you. Now, Senator Stanley.
Thank you. Good afternoon, Mr. Chair, members of the committee. Before you is Senate Bill 906, of which I am the chief co-patron along with Senator Rome. This summer, we worked on the bill actually that was offered by Senator Favola last year, and I attempted a floor amendment which lost by one vote, but we took a look at what we think is a real issue that needs to be addressed here. And, you know, you may not be able to get rid of dark money in politics, but you can certainly force sunlight upon it. 906 updates Virginia's campaign finance disclosure requirements by enhancing transparency in political advertising and especially in independent expenditures. What we're trying to do here is modernize existing regulations that will address the current campaign practices while maintaining reasonable thresholds of compliance. Here are the changes to what the existing law is right now. This bill would, with regard to independent expenditure thresholds, raises reporting thresholds from 1,000 to 5,000 for statewide elections, raises the reporting threshold from 200 to 1,000 for other elections, maintains 24-hour reporting requirements for transparency. It requires top donor disclosure of the top 3 contributors for independent expenditures involved in a campaign in the Commonwealth of Virginia, and that would apply to print, television, and radio, and all advertisement. Exempt small spenders under $20,000 per election cycle. What we're looking at is trying to get transparency for these very large not-for-profits, 501c3s, C2s that are doing this. Clarifies under digital advertising the requirement for online political advertisement, maintains a 7-point minimum font size requirement on ads, and allows click-through disclosures for space-constrained ads. The regulatory relief that you would find in this bill is that it reduces compliance burdens on smaller organizations and campaigns. It streamlines the reporting requirements while maintaining and encouraging transparency. And it updates the thresholds to reflect current campaign costs. I think the numbers being so low didn't reflect what our campaigns have now astronomically become. Enhanced transparency is a cornerstone of this bill. It improves voter information about funding sources, strengthens disclosure requirements for large spenders, modernizes requirements for digital advertising, and creates some administrative efficiencies. It reduces processing burdens on our election officials, focuses oversight on more significant expenditures, and maintains a strong enforcement mechanism in place. This bill represents a balanced approach to campaign finance disclosure, especially when it comes to dark money. It reduces bureaucratic burdens while enhancing meaningful transparency, which we should all be about. By raising the reporting thresholds, we're helping smaller organizations participate in the political process while maintaining oversight of larger political spending, which we're seeing a lot of in these state and even local election. In the bill, the top contributor disclosure requirement ensures that voters know who's funding significant political messaging without overburdening smaller participants, and modernizes our disclosure requirements for the digital age while traditional standards are still kept in place.
Senator Stanley.
Sir.
Is this the same as that bill we heard last year before this committee?
Mr. Chairman, I would say that it's the same bill from Favola with plus, what we added to it, which was the floor amendment that was supported by my chief co-patron, Senator Rowan.
I understand. Senator Stanley, have you spoken to the ACLU or the NAACP in their position, they were in strong opposition of this bill last year?
Mr. Chairman, I have not. My door is always open for those organizations that want to speak to me, no matter who they are or what position they may take on my bills, but I've not had it. Your Honor. Mr. Chairman, I do have one issue when the drafting of it, which was last year's drafting, if I can find the line. It's in the definition section. The only concern I had, and it was brought to me, and I think we can address it if I can find it, is under the disclosure requirements. That would be line 176 in the definition of electioneering communication. And that definition means any message appearing in the print media or television, radio, online platform, Romanet 1, that refers to a clearly identified candidate. What we're seeing here, and I think Senator Rome will probably talk to this and what she experienced in her campaigns, is that mere reference to a candidate's not there. Usually it's advocating for or more often against an opponent, another candidate in the same election. And then what happens is no one knows where it came from, and no one knows who put the money up for it. This bill tries to do that. So when we talk about 176, there may be a requirement or a need to amend that so that it's advocating for or against a particular candidate, because referencing could be almost anything. If, we do have some exceptions where advertisements for forums or debates are not, and that's found on line 180. Electronic communications does not include A, candidate debate forum promotion of such a debate or forum, or B, a communication paid for by federal candidates in connection with federal elections. But what we want to do is bring the transparency when a lot of money is spent, and I think you will address this as well, on mailers, on digital communications, excoriating someone who's running her office, and it's done with dark money. Who did it?
Thank you, Senator Stanley. Senator Deeds.
So, Mr. Chair, Mr. Senator Stanley, you would take refers on line 176 and change it to advocates for or against?
I think that's, Mr. Chairman, I'd answer the gentleman by saying I think that's clearer, because refers might be, unless council has a different idea. Refers could be a very general thing. So if you mention a candidate, are you subject to this bill? This is really going after, and of course with concurrence of
I'd move that amendment to strike refers and say advocates for or against.
A particular candidate.
Yes.
Or it says a clearly identified candidate.
All right, there's been an amendment. It's been properly seconded. You get that, Brooks? All right. All those in favor, say aye. Aye. All those opposed? All right, that bill has been amended.
Mr. Chair, I'll try to speak generally briefly to this. Last year on the floor, you'll remember the great infamous Bill Stanley rip slap of 2024 when I said that he did not get the patrons' permission before introducing the amendment, whatever. And I made a promise that I would, in fact, work with him in the off season. Indeed, did drive down to Smith Mountain Lake where we worked this out in person. And what happened, and part of the reason for this is, you'll remember last year I said I had 40 negative mailers sent against me, in the campaign. My campaign team members are informing me later that it was actually 41. And so I want to highlight one example of where this is a problem, okay? Never mind the content. The content is so ridiculous that's not even worth redressing. The question came, who is it from? And at the very bottom it says, paid for by Great American Coalition, not authorized by any candidate or candidates committee. And then you have this mailing address out of DC. Go ahead online and try tracking down who set that up, who that committee actually belongs to. Try to find any information about them, who donates to them. Try to find anything. And what you'll end up finding is it's not just this. This happens over and over again, where you have these innocuous sounding named groups that just come in and with unlimited resources because of Citizens United, as mentioned earlier, through independent expenditures, they can just flood the zone. What Senator Stanley and I are advocating for is transparency in that. It's really standing by your ad, not just for the candidates, but anyone who wants to play in the arena, stand by your ad.
Thank you, Senator Rome. Senator Deeds.
So, Mr. Chair, Senator Rome, would the disclosure of these three largest contributors be on the ad itself?
Mr. Chairman, I would say, just making sure, but the answer I believe is yes. That was what we worked out.
And Senator Deeds.
No, that is provided where? What line? Direct me to that specific language, please.
Hold on.
Okay, wait. I see it. It's on line 266. Okay.
You beat me to it. Yes, sir.
Thank you.
And so, Senator Stanley, Senator Ronan, who wants to answer this question? And so, you all had all year to work on this bill, correct?
That's right.
All right, and you heard the concerns from the ACLU and NAACP last year. Have you addressed their concerns?
Mr. Chairman, I thought that what Senator Stanley did would have addressed that. And at the same time, I don't know if there's anyone from them who are here to speak on the bill, but we'll find out.
All right. Is anyone here speaking in support of the bill?
Yes.
Okay.
Online in support, please raise your hand.
You have 1 minute.
Mr. Chair and committee members, Mary Crutchfield, League of Women Voters, Virginia. The League of Women Voters supports this bill as an important step in enhancing Virginia's transparency of campaign funding and the electorate's ability to know who is trying to influence their decision. The League supports the increases in disclosing and reporting dollar thresholds and the requirement that independent expenditure reports be filed electronically. Thank you, Senator Stanley.
Thank you.
All right, you have 2 people online. Please ensure your camera's on.
Nancy Morgan, you may begin.
Thank you, Mr. Chair, and it's so delightful to see a bipartisan approach to dark money. Many of your colleagues from this body have been subject to these attacks, and this, just to remind ourselves, that Citizens United, when it was passed, the justices on the Supreme Court voted 8-1 in favor of full disclosure. And in fact, when you look at, apart from this, the ACLU or Americans for Prosperity, when you look at it, state and federal litigation has supported similar legislation in many states, Arizona, Alaska, Rhode Island. So disclosure is the law of the land. And
Thank you, ma'am.
Thank you.
Please ensure that your camera is on.
Please turn on your camera, unmute your microphone, and begin.
Rivas. Hello, my name is Jackie Rivas, and I represent We Have Action. We support greater disclosure of donors to the State Board of Elections.
You need to have your camera on. That is our rule here. And if your camera's not on, then we cannot take your testimony. Okay. Is there anyone okay. Noted. Anyone in opposition in the room?
Opposition, please raise your hand.
You have 2 minutes, sir.
Mr. Chair, members, Chris Kaiser with the ACLU of Virginia. Let me start by saying I appreciate that amendment that you all talked about. I think that makes the bill better. Zooming out a little bit, the First Amendment issue here is that nonprofits do have a fundamental right to maintain the privacy of their member and donor lists. There are good reasons for that. Those rights are recognized first in cases where the NAACP defended their right to keep their member list secret from the state of Alabama in the Jim Crow era, things like that. Now, that's not an absolute right. That can be tempered against governmental interests in combating corruption in elections. So hear that completely. But nevertheless, that is a content-based regulation of core political speech. So it's going to have to satisfy exacting scrutiny, which means it has to be narrowly tailored to that interest. As introduced, the bill was really overbroad because of that just sheer reference to a candidate. I think it becomes more constitutionally defensible if we zero it in on supporting or opposing a candidate. Respectfully, I would ask that maybe the amendment refers specifically to supporting or opposing the election of a candidate so that it's not just kind of squishy about making positive or negative statements. Nevertheless, I'm in the opposed line because I do think that's still a constitutionally questionable position. A couple federal courts have taken this up. The Supreme Court hasn't. Not everybody has agreed. So I think there's a chance this still gets struck down. But with that amendment, it's better than it was. So appreciate that.
Well, Mr. Chairman, I did talk to him.
Mr. Chairman, Benjamin Knotts, Americans for Prosperity. Senator Van Valkenburg probably could tell you about American history and a lot of anonymity in the founders, or in Benjamin Franklin from the Sons of Liberty, and all the anonymous things they were trying to do to pursue the revolution. We see that in history. It's an American tradition of right to association and privacy. So one thing I will say is that there's been this problem brought up of basically C4 that's acting like a PAC. And that's something I think that could be studied and we would like to participate in, but we oppose the bill as it is written. Thank you.
Thank you. Anyone online? We have one person online in opposition. Please ensure that your camera is on.
Melody Clark, you may begin.
Yes, thank you. Good afternoon, Mr. Chairman. It was nice to meet you in person last week. I am Melody Clark on behalf of Virginia Institute Action. After careful consideration, we ask you to vote against SB 906 because it will weaken the ability of organizations to mobilize voters, advocate for critical issues, and amplify the voices of underrepresented communities. It will infringe on constitutional protections, inviting costly and time-consuming legal challenges, specifically U.S. Supreme Court ruling on the right to donor privacy in NAACP versus Alabama. This legislation is harmful to organizations supporting candidates of progressive.
Thank you so much. All right, is there any, I see Senator Van Valkenburg.
Speaking to the bill in a motion at the appropriate time.
Okay, we have now is the appropriate time.
Thank you, Mr. Chair. Mr. Chair, members of the body, I did vote for this bill last year. I'm not going to vote for it. Last year, I'm not going to vote for it this year, and I'm going to explain my reasoning why. The ACLU brought up NAACP versus Alabama, which was when the state of Alabama was trying to pry open the NAACP membership list as a form of retribution, right, as a way to prevent political action. And I think the events of the last couple months have shown us that we have political figures in this country that are willing to weaponize membership lists. And once that whatever the metaphor is, it's late in the day. But once that kind of gets open, I'm not saying that that's going to stay with one person. And I think I've got a lot of worry that over the course of the next 10, 20 years, we're going to see politics get a lot rougher in that regard. And so I'm going to be voting no. And so my motion is to pass by indefinitely.
Second. The motion second to pass by indefinitely. Senator Deeds.
Mr. Chair, I make a substitute motion. I want to encourage this nexus of Rome and Stanley. I think it's bipartisanship's a good thing. I think we're not talking about a list. We're talking about the three largest contributors. I'm going to vote to move to report.
Second.
All right, so substitute motion takes precedence. That motion to report, what's the substitute? Please open the vote.
Drum roll, please.
Boys did not come through.
That bill fails to report. Thank you, Senator Stanley.
Thank you, Mr.
Senator
Chairman.
Rowan, but you two can continue to work together.
Absolutely, Mr.
So,
Chairman.
okay, now
I
we
enjoyed
go
working
back to the
with the
original
Senator. She's
motion. Before us, the PBI. Please open the vote. Pass the PBI.
That's your motion.
No, we're losing votes.
10 knows 5.
All right, thank you. Now we have, we'll take Senator DeSteph. We heard this bill last year. You can do it from the dais, sir. Or from the podium, whatever your preference. All right.
Mr. Chairman, members of the committee, oops, I grabbed the wrong folder. Give me 1 second. Sorry, Mr. Chairman, members of the committee. Let's try this again. So what we have here is
Senator DeSteph?
Senator, we heard this,
Mr. Chair.
Sorry, Senator Evan.
Is this identical to the bill that this committee reported last year on a bipartisan vote?
Yes, sir, it is.
All right.
Okay.
Thank you. There's a motion to report. It's been properly second. If the patron wants to take his chances with the committee, I think we open the vote.
I'm sorry.
There might be people want to talk to it.
I'm happy to just move it on.
All right, please open the vote.
Thank you, Mr. Chairman, members of the committee.
That's 15 knows 0.
Senator Sturtevant.
Mr. Chairman, members of the committee, this is Senate Bill 1454 before you. It is a bill that provides that the Department of Elections is required to implement policies and procedures necessary to ensure that processes are in place to validate voter registrations and prevent non-citizens from registering to vote. Such processes must include cooperation with state agencies to ensure that non-citizen registrations are not included in the registrations forwarded to the department, effective utilization of all data available for identifying non-citizens, including data provided by state and federal agencies, a monthly systematic review of the voter registration system to identify non-citizens, and display of messages communicating the citizenship requirements for registration and penalties for violation. And that is a summary of the bill, Mr. Chairman. The need for this, I think, comes out of what we saw towards the end of the summer when there were reports of, I think, upwards of 6,000 plus non-citizens who were identified on our voter rolls. And the governor's administration had begun working through the process of getting them removed from the voter rolls. There was obviously litigation back and forth with Department of Justice over whether that could be done within 90 days of the election. And I know, Mr. Chairman, you have a bill to address that issue. This is separate from that. But the idea here is that we all want to have safe, free, and fair elections voted on by people who are American citizens. And we've now seen pretty substantial evidence that our voter rolls have included not an insignificant number of individuals who are not eligible to vote because they're not American citizens.
Senator Dees.
Mr. Chair, Senator Sturtevant, I think we all agree that only American citizens should vote, but isn't the problem that was identified last year primarily a problem with people checking the wrong box at the DMV?
Mr. Chairman, Senator Deeds, I think that was one of the issues that was addressed, that you had non-citizens going into the DMV.
Mr. Chair, what other issue was there? Tell us.
Well, I think the question is there could be a whole host of different, there could be entities that are signing people up, registering them to vote, and that's making its way through the process. But regardless, I mean, the issue that you raised was that people were checking a box identifying that they were not a citizen with the DMV, and yet were still able to make it through the process to get themselves registered to vote in Virginia. And I think that is ultimately the issue that we need to make sure is addressed. Because this is, I think, you know, when this issue has come up previously of folks illegally registering people to vote, it's been a small handful of people. I think it was raised at the last meeting of this committee, a small handful of people were registered. You know, they were names in a graveyard out in the western part of the state. And so when this issue has typically come up, or somebody has been charged and prosecuted for doing illegal registrations, you know, admittedly, it's typically been a small number of registrations. What we saw this past summer leading up to November is when you're talking about 6,000 plus non-citizens who are on Virginia's voter rolls, that is a substantial number that could impact the outcome of elections were they to all go and vote.
Senator Deeds.
So that the vast majority of those people are folks that came through the DMV that checked the wrong box. Admittedly, they checked the wrong box and they were registered. There's no evidence that any of those people voted, is there?
I don't know the answer to that, but I do know that they are, in fact, they
Well, just a
were
second.
registered to
Just
vote.
a second, Senator Sturtevant. Is there evidence? Because I haven't seen any evidence that those people actually voted.
Mr. Chairman, Mr. Chairman, Senator Rouse, I think the issue is that you have thousands of non-citizens who have been able to get themselves registered to vote in Virginia. Whether or not they have voted is an important question to ask and to look into. But we have the initial issue of them being registered to vote in the first place. And when we have had elections that have come down to a tie vote or to a very small single-digit difference in votes, when you have thousands of individuals who should not be on the voting rolls and everyone agrees with that, that puts our democracy and the results of our elections at risk.
Senator, listen, I don't think anyone, especially around this committee and dais, would want any person who's not a citizen voting. But I think what the point that Senator Deeds has raised is that it was by a mistake, and there's yet been any evidence that has shown non-citizens actually voting. In fact, I don't know of anyone that was actually in our country illegally that's actually trying to vote as to bring awareness to their illegal status. And so that's just unfounded and not heard of. But we do have a queue, and we do have senators in the queue. We'll go down to Senator DeStelf, followed by Senator Van Valkenburg.
Mr. Chair, I'd like to first see if we've got Shelley Oberlander, who's the Electoral Board Vice Chairman, and the Electoral Board, I guess, Association President. Is she online by any chance?
Well, hold on, because before we take testimony from anyone who is in support or opposition, have senators in the queue. So do you have a question?
And actually, if she was online, I was not going to ask my question. Since she is online, I'm sorry, since she's not online, I will ask the questions, because I had a conversation with her on this today. And it seems that when folks are checking the wrong box inadvertently, they're also getting jury questionnaires and being called to juries. And she said that they've got to find a better way to clean the rolls so they are not including them in juries. And with a few of these, she said that we're trying to, and again, I'm going to quote her terms on this, says we're trying to help prevent them from committing a felony, because when we send them a jury questionnaire, we're basing that off of the fact of what they checked on their driver's license. And I don't know if Senator Sturtevant, if you had a conversation with her or if you've seen this issue, but she said that this was one of the big issues that they saw this bill solving for them. It's folks who are beyond, outside of their knowledge, committing a felony when they're getting these juror questionnaires, they're filling them out, and then they're going in to serve on a jury.
Sure.
And that's where we're catching people up, and it's not, again, this helps solve that problem, according to her when we were sitting down and going through some of these issues. And her comment was, hey, we're not trying to charge somebody with a felony, but these are some of the unintended consequences when folks check the wrong box. And then in the process of that, they're now being called to a jury or a grand jury, being sworn in,
and it goes all downhill from there. So she was saying that this is a way to fix that.
Thank you, Senator D. Staff. But as far as pertaining to the issue of voting, jury duty is a different issue, and surely one that any senator should want to bring a bill to ensure that people are serving on jury duty are actually accurate in who they pertain to be. But there's list maintenance, voter and registration maintenance that happens periodically all the time.
Mr. Chair, as someone that tries cases with juries, I can tell you that it's not that easy to get on a jury. There's a questionnaire they've got to fill out, and there are a lot. I can assure you that at least on the juries I've seen, you've got citizens only.
We do have a queue. So Senator Van Valkenburg.
Mr. Chair, I just have a motion and speak to that motion at the appropriate time.
Senator Eben.
I'm going to second Senator Van Valkenburg's motion at the appropriate time, but I did want to just state for the record that the list of 6,000 people is not an accurate figure. There were lots of news articles with examples of citizens who were on that list of 6,000 people who were purged and only found out that they'd been removed from the voter roll when they went to vote, legitimately went to vote. This bill is a sledgehammer to an ant, and I would also dispute the phraseology that people, non-citizens, are being sworn in for grand juries or juries in this Commonwealth. No one wants to go to jury duty regardless of citizenship status, in my experience, except for me. I don't get picked, though. But if this bill was a DMV elect work group to work on the interface between those agencies, that'd be one thing. But this is really a sledgehammer to an ant on a problem that is not turned to be reality of non-citizens voting, to my knowledge.
All right, we have, and listen, we still have to take testimony real quick, but Senator Cyphers, you are in the queue, sir, so you have the floor.
My question would be for Mr. Chair, the question for the patron is if it's this easy to check the wrong box, wouldn't it be just as easy for a non-citizen to check the wrong box and end up on the voter roll inadvertently?
Mr. Chairman, Senator Cyphers, I think that is the issue that this is addressing, is you have a non-citizen who is checking the wrong box for one reason or another. Certainly there's a language barrier challenge, perhaps in some circumstances, but regardless of the reason and the intent, whether good intent, bad intent, indifferent intent, we have a lot of evidence that those individuals are making their way through the process such that they are ending up with a voter registration card and are registered to vote in Virginia. And as Senator DeStaff pointed out, that can get you put on the roll of eligible jurors, which can compound the problem if those eligible jurors who are eligible jurors in quotes who are non-citizens get a jury questionnaire that perhaps they have to sign under penalty of perjury and return back to their local court, depending on how that local jurisdiction does it. Again, they may be confused and it may be unintentional, but if they sign that juror questionnaire and send it back in, that potentially could put them on the hook for prosecution for a crime. And so again, there's a ripple effect once these individuals get themselves into the system on the voter rolls.
Thank you, Senator. All right, now it's time. Do you have anyone in support of the bill?
Those online in support, please raise your hand.
I don't see anyone in support. Is there anyone online? Yes, in support of the bill? All right, please add 30 seconds on the clock. Please ensure that your camera is on as well.
Ann Gregorian, you may begin.
Yes, in my locality, there were referrals for illegal registrants voting as non-citizens, but briefly, for over a decade, DMV has not complied with Virginia law to transmit data for use with the DHS SAVE program, and ELECT has made no attempt to correct this failure. From 2020 to 2022, DMV stopped all transmission of non-citizen data, and ELECT never noticed. FOIA has revealed that DMV has repeatedly provided erroneous citizenship data to ELECT, with the latest incident occurring between April and August of last year. This bill will require DMV to comply with the law.
Ma'am.
Mandate ELECT to
Please ensure that your camera is on.
Good afternoon, Mr. Chairman, members of the committee. I am Melody Clark on behalf of Virginia Institute Action. We thank the legislator for bringing forth the bill. We believe it should include a requirement for more robust data sharing agreements between ELECT and other Virginia agencies. not only on the side of elect. All Virginia agencies should be required to have MOUs with the Office of Elect to provide comprehensive data for maintaining and updating our voter rolls. Also, I refer you to a public interest legal foundation report that showed non-citizens in Virginia not only registered to vote by the thousands, many actually cast ballots in our elections. I am Melody Clark on behalf
Thank you,
of
ma'am.
Virginia Institute.
Is there anyone in the room speaking in opposition of the bill? Please come forward. Seeing three, each have a minute, 3 minutes on the clock total.
Online in opposition, please raise your hand.
Mr. Chair, members of the committee, Tram Nguyen with New Virginia Majority. We strongly oppose this legislation. I agree with Senator Eben, this is a solution in search of a problem. We've had a lot of conversations about list maintenance over the years, and more recently about the quality of the data. And this bill includes list maintenance based on data that is known to be inaccurate. For example, from the Social Security Administration. The Inspector General of the Social Security Administration has already admitted that their data is flawed and should not be used for voter registration purposes. So we strongly oppose the bill. Thank you.
Mr. Chair and committee members, Mary Crutchfield, League of Women Voters, Virginia. Only citizens should be registered voters, but this bill resorts to draconian measures, such as requiring that certain jury questionnaire responses be transmitted to general registrars. The voter registration system should not be used to put a person who accidentally misstates citizenship on a jury questionnaire in jeopardy of perjury. The bill could lead to unwarranted disenfranchisements, such as those we've already experienced in the past 2 years, and is also an example of needless government overreach. We urge you to vote no on SB 1454.
Mr. Chair, members of the committee, Sheila Hurley-Hennessy with the Virginia Interfaith Center for Public Policy. We also oppose this bill. There is already a system to remove ineligible voters from the voter rolls, and the issues we have seen, especially in the last year, have been more in line with folks who were in fact citizens checking the wrong box and accidentally calling themselves non-citizens than folks who were not citizens accidentally checking the box and calling themselves citizens. So we want to make sure that all those who are citizens and are eligible are in fact able to exercise that right to vote. Thank you.
Jimmy Hart, Richmond resident. I think this bill is just an obvious attempt at voter suppression to boost voting numbers for the patron. And the 6,000 number is just a complete lie. The number of voters attempted to be removed from the registration was 1,600 in Virginia, and absolutely zero of those people were proven to be non-citizens. There's no substantial evidence showing they're non-citizens at all. It's just made up information.
All right, there's no one online. Now, Senator Valkenburg.
Thank you, Mr. Chair. Mr. Chair, I move that we pass this bill by and speaking to that motion.
Is there a second?
Second.
The motion is to PVI and it's been properly seconded. And Senator Valkenburg.
Yeah, Mr. Chair, I would just say that there's been 3 elections under the current administration, and 2 of them they've had oopsies with the voting rolls, and then they also, in those 3 years, took us out of the most effective tool for list maintenance, ERIC, which they then vetoed a bill when we tried to make them rejoin it. And so that, you know, the lists work, the lists are up to date. There's no problem here. This is a solution in terms of a problem, and we should join ERIC if we really think that there's an issue. So I move to pass it by.
All right, we have a motion. There's a second. Please open the vote.
Ayes 8, no 7.
Thank you.
Thank you, sir. And last but certainly not least, Senator Dees.
Maybe it is the least. The first will be last, and the last will be first, right? I've got, and I'll just do it from up here if that's all right. Senate Bill 1469. I've been around this place for a few years, and I've introduced several of these limit bills. And I tried to be as thoughtful as I could, and I've been, this bill, somewhat the limits are low, but I think the law ought to inspire confidence in people, and while I see a lot of cynicism about the political process sometimes. So 1469 attempts to establish reasonable campaign contribution limits. Specifically, the bill sets the caps at $5,000 for statewide races, and the Senate, $3,000 for House of Delegates candidates. The limits apply to the entire election cycle. Under the bill, they're adjusted based on the Consumer Price Index. The caps do not apply to in-kind contributions from political parties. The bill establishes thresholds for any candidate making contributions to their own campaign at $400,000 for a statewide race or the Senate, $200,000 for somebody running for the House. The bill also prohibits contributions or any combination of contributions that exceed $10,000 to any one political committee in a campaign year or in a calendar year. The civil penalties for violations of the limits established by this bill could equal up to 2 times the excess contribution limits. Finally, the bill has a delayed effective date of January 1, 2026, so it wouldn't apply to this election cycle this year. Virginia's elections are some of the most expensive in the country. Some of the research, some of the numbers are astounding. During the last election cycle, our legislative races alone cost about $206 million, compared with $26 million for all the races in North Carolina and $37.2 million for the races in Pennsylvania. There are only 12 states without limits. To restore confidence in the process, we need campaign finance reform, and that's what Senate Bill 1469 is all about.
All right, thank you, Senator. Is there anyone here to speak in support of the bill?
Support, please raise your hand.
Please come forward. Please put 2 minutes on the clock.
Thank you to the committee and the chair for this consideration, and Senator Deeds for his leadership. Wes Gobar with Clean Virginia. I'd like to use my time to also echo some of this data that Senator Deeds referenced. I did some math this morning on Open Secrets, looking at other sites, and the status quo is not working on campaign finance. Virginia has less than 9 million people, but the most expensive legislative elections period in 2023, 26 million raised. More than 3 to 4 states with more than 3 to 4 times that population have less expensive elections. In fact, we have the most expensive elections per person in the entire country. And I counted, you often hear about dark money, independent spenders, political committees. That same stat about the most expensive per person is true when you also count independent spending and political parties. So again, that's actually $44 per person raised across the entire Commonwealth in 2021. That's like half a day's minimum wage work. Or for reference, Texas and Pennsylvania cost $21 per capita. Huge states, bottom lines, these are the states with caps and disclosure, have much cheaper elections, and the costs are continuing to go up every year. I'm glad witnesses here, like Virginia Natural Gas, recognize the importance that we have a political spending problem, and hope they're also willing to join us in calling for comprehensive contribution limits. Thank you.
Mr. Chair and committee members, Mary Crutchfield, League of Women Voters, Virginia. The League of Women Voters supports legislation that limits campaign contributions. Corporations, particularly public service corporations and the Political Action Committee, should not be allowed to make contributions to any candidate's campaign committee or political action committee. Again, this is an issue of conflict of interest. Please support this bill and vote yes. Thank you, Senator Deeds.
Thank you, ma'am.
Jimmy Hart, Richmond resident. Yeah, if you're voting against this,
Just
you've
your
got to
name
be
and
compromised.
just
Sorry,
your name
sir.
and your position.
Apologies. I support the bill.
Thank you, sir. Anyone in opposition of the bill? Oh, we have 2 online to speak in support. Please ensure your camera is on.
Morgan, you may begin.
You have 30 seconds.
Thanks again. 3/4 of Virginians support campaign finance limits. I get an echo here. Anyway, they're common sense and supported by citizens, and we thank Senator Deeds for championing this bill.
Thank you.
Bill Millhauser, you may begin.
Mr. Chairman, members of the committee, I totally support this bill.
I completely agree with the comments by the sponsor and Wes Gobar concerning the high cost of our elections in Virginia. I do also want to point out that large donors are completely overwhelming the voice of small donors in our election system here in Virginia. And I also note states surrounding Virginia, Maryland, West Virginia, and North Carolina all have campaign finance regulation regimes such as this. Thank you.
Thank you, sir. Going to, you have anyone in opposition of the bill?
Those online in opposition, raise your hand.
All right, Senator Van Valkenburg.
Thank you, Mr. Chair. Mr. Chair, members of the committee, I talked to Senator Deeds before about offering some amendments if he would be friendly to them.
I think this is an important notion, but the limits are mine alone, so if you've got ideas, that's.
So, Mr. Chair, let me just share my fears with the limits being low. I think there's a couple things that we need to note that make Virginia unique. The first being that we're the only state really that has off-year elections, which really does contribute to the expense. I would encourage us all to vote for Senator Serville's resolution to try to get us on even years, because if you want to talk about how you can make spending on state elections go down, it's to put us on even years. And I think the second reason, when you take that, we're the only game in town in an off year, and then we're a purple state, where both sides think that they can create a national narrative, you're gonna have a ton more spending in Virginia, regardless of the campaign finance laws. And so my biggest fear with, because I've put in bills around campaign limits and I'm supportive of the principle, but my biggest fear is that if you don't do it carefully, all you end up doing is taking that money and sending it to dark money. And if you follow congressional campaigns, the candidate asks for the minimum that they can, or the maximum that they can get, and then they suggest that the donor go call the group that's helping them where they can raise more money. And then that group is the one that does most of the spending in the congressional race. So they're still raising money, albeit in a very indirect and I would argue more corrupt way. And so I do want to vote for the bill. I think the limits are very low. And I think we should start high in the name of making sure we don't do harm, especially if we're still off here. And so I wanted to throw out there, I'm not sold on it, and Senator Dees, please feel free to say no. But I wanted to start out with saying 50,000 and 25,000 at the top for the statewides, and then the 25,000 for the House. And feel free to say no, Senator Deeds.
If this is the last bill we have before this committee, and you two gentlemen need to negotiate something, perhaps you all can go over there and come back with an amendment while we take further testimony from members of the committee. All right, Senator Eben.
I had.
All right, we will be temporarily at ease.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306.
All right, We're on the last bill of the day, and Senator Evans.
Mr. Chairman, I was going to suggest, I like the spirit of this bill. Senator Van Valkenburg indicated interest in a little bit higher limits, or much higher limits, and I wanted to see the Senate not treated the same as governor and lieutenant governor and AG. So, but in the interest of time, I was going to suggest we report the bill and that the committee members of the committee who have input give it to Senator Deeds for a possible floor substitute.
All right, you got that. Do you have that?
So no changes tonight, just.
No changes tonight. All right, got it. Thank you. Senator Sturdivant.
Yeah, thank you, Mr. Chairman. Just briefly, question about the bill and its application. The scenario I'm thinking about is you have a elected official who swears off PAC money. They don't take any money from any special interests. Don't take any utility money or whatever. But they accept plentiful money from like leadership PACs, which is filled with money from utilities and corporations and special interests. How is that scenario dealt with by this bill?
Mr. Chair, I would say that the monetary contributions, whether they are from a party or from a corporation or individual, are the same. The one thing that's different is in-kind contributions from a party or a party committee.
All right, thank you. Is there a motion before us?
Move to report.
All right, the motion is to report, and the second, does that go to finance? Sure. All right, motion to report. Let's be properly second. Please open the vote.
It's 8:07.
8-7, that bill reports.
Thank you very much, Mr. Chair.
All right, that concludes today's hearing.
Now they're trying to talk them down from going crazy.
Yeah, I mean.
The Senate of Virginia, Richmond, Virginia. Senate